An Iowa school district has been sued after parents were alarmed to find the district's gender support policy meant students could hide their gender identity from their parents. Well, joining us today to discuss the issue is President of Parents Defending Education, Nicole Neily. Happy Tuesday. Good morning to you. Thanks for joining us.
Thank you.
So your organization filed this lawsuit claiming the district violated students' First and 14th Amendment rights. Tell us about the lawsuit and how your organization got involved.
Sure. So Parents Defending Education has a tip line, and a parent in the district sent us a tip, asked for the school board pass this policy in April. And what the school policies that we have that we're challenging include are the fact that children can start a gender support plan at any age, so beginning in kindergarten, but beginning in 7th grade, the student's preference takes precedent over that of the family. And so from 7th grade on, about 12 years old, a family might never know about this information. And the district actually goes out of its way to deliberately hide this information by placing that into a temporary file. Parents are actually entitled to read their children's files under FERPA, which is a federal privacy law. Yet by putting this information into a temporary file, parents will never have access to that information. And then the other part of this is if a student misgenders or uses the wrong pronoun for one of their peers, they can be subject to punishment up to and including expulsion. And so those are both policies of significant concern, and that's why we had to file a lawsuit in federal court.
Well, the Linn-Mar School District's parental exclusion policy, we wanted to get the actual what it states here. It states that any student in 7th grade or older will have the support of the school, and the district will not disclose a student's transgender status to parents unless the student authorizes it. How long has this policy been in place? Do you know?
So it was ratified on April 25th, although the district in its communications to parents said that this has been in effect for 5 years and they were merely ratifying it, which was of news to parents in the district because the problems that happened after the policy was passed, including boys going to the girls' restrooms, trying to take pictures and stuff, had not been occurring until then. There were girls at the end of the school year from when this policy passed until when kids got out, where girls just refused to go to the bathroom. They refused to change for gym class because they were so nervous and uncomfortable. Those things had not been happening before, and so the fact that the district says it had been in place is deeply questionable.
Yeah, and you mentioned before that this plan is kept in a separate temporary file so that materials and records related to the gender support plan will never be essentially accessible to parents. What does the law say? What are the rights of parents? Do they have a say in this matter?
Parents have a right to their children's files, to their children's medical records. These are minors. I mean, at the end of the day, these are children under the age of 18. There is a strong, federal courts have found over the past 100 years, parents have a right to direct the upbringing of their children, even over the objections of their children in medical cases. And so this is something where, the school district seems to be going out of its way to pit children against their parents, because I think many kids don't think of their families as being unsupportive or unsafe. And frankly, the vast majority of families are loving and supportive. And so for school districts to put this idea into children's heads and say, you can't trust your family, but you can trust us, is really worrisome.
And you mentioned that students who refuse to use the student's self-proclaimed pronouns or name, they could be expelled from school. What about for staff? What about for teachers? What could happen to them?
They can also be subject to discipline. And so for faculty members, they could be subject to discipline up to and including termination. And so again, it's a significant violation of everyone's First Amendment rights because it goes against their conscience. And, in some cases, the district is able to determine whether something is intentional, is malicious. There is no such carve out in the First Amendment. The First Amendment protects freedom of speech, period, the end. And it doesn't give administrators the bandwidth to pick winners and losers in this situation.
Nicole Neily, President of Parents Defending Education. We appreciate you joining us.
Thank you.
Thank you. Have a great week.